Chapter 3. Definitions. Section 57. Difficulty of defining domicile. The difficulty, if not impossibility, of arriving at an entirely satisfactory definition of domicile has been frequently commented upon. Lord Alvanley, in Somerville v. Somerville, praised the wisdom of Bunkershaw in not hazarding a definition, and Dr. Lushington, in Malthus v. Malthus, speaking of the various attempts of jurists in this direction, considered himself justified in applying the remarkable language of Hirtius, Veheminis definiendis miremist quam student doctors. Lord Chelmsford, speaking, as late as 1863, in the case of Morehouse v. Lord, says, the difficulty of getting a satisfactory definition of domicile, which will meet every case, has often been admitted, and every attempt to frame one has hitherto failed. Still it is desirable, if not absolutely necessary, at the beginning of a treatise to arrive at, with at least approximate accuracy, a general conception of the subject which it is intended to unfold. It is proposed, therefore, to give some of the most celebrated definitions, together with such criticisms as have been passed upon them by others, and such also as may appear to the writer necessary and proper. Section 58. Definitions of the Roman Law, Code. The oldest and by far the most celebrated definitions of domicile are those which are to be found in the Roman law, the one most frequently quoted being that of the Code, in the Odem loco singulos habere domicilium, non ambigatur, ubiquis lem, rurumque, ac fortunum sarum sumam constituit, undrursus non sit decessores, si nihil avesset, undcum perfectus ist, peregrinari videtur, quod si redit, peregrinari jam destitit. Dunillus criticizes this definition as possessing more elegance than certainty, and Lord Alvanley declares that its words are very vague and difficult to apply. It is to be observed that it is hardly a definition, but, to use the expression of Lord Cranworth in Wicker v. Hume, more properly an illustration. There is no doubt that the circumstances set forth would suffice to constitute domicile, but would not circumstances far less cogent suffice? Westlake remarks that it would not be just to the Roman emperors to represent them as having attempted a definition, in that pathetic description of home so often and deservedly quoted. Section 59. Id. Criticism of Lord Cranworth in Wicker v. Hume. In Wicker v. Hume, above referred to, Lord Cranworth thus speaks of this passage: upon the subject of domicile my noble learned friend has alluded to one definition which he said came from the Digest. It is also to be found in the Codes, and was a principle of the Roman law. There have been many others, but I never saw any of them that appeared to me to assist us at all in arriving at a conclusion. In fact, none of them is, properly speaking, a definition. They are all illustrations, in which those who have made them have sought to rival one another by endeavoring, as far as they can, by some epigrammatic neatness or elegance of expression, to gloss over the fact that, after all, they are endeavoring to explain something clarum per obscurum. By domicile we mean home, the permanent home, and if you do not understand your permanent home, I am afraid that no illustration drawn from foreign writers or foreign languages will very much help you to it. I think the best I have ever heard is the one which describes the home as the place. I believe there is one definition in which the lares are alluded to, the place, and non sit decessores si nihil avesset, undcum perfectus ist, peregrinari videtur. I think that this is the best illustration, and I use that word rather than definition to describe what I mean. Section 60. Id. Criticism of Kindersley, v. C. in Lord v. Colvin. The remarks upon the same definition by Kindersley, v. C. in Lord v. Colvin, are so appropriate and elegant that they are here given in full. It is not my intention to enter upon an elaborate discussion of the various definitions which have been given or attempted to be given of the term domicile. At the same time it is impossible to avoid some reference to them. I concur with the observations of Lord Cranworth in Wicker v. Hume, that many of them are rather illustrations than definitions. Some of them also appear to me objectionable, because they are expressed in language more or less figurative, which ought never to be the case in what professes to be a definition. Some of the Roman definitions are utterly inapplicable to the present condition and habits of mankind. The Roman definition most frequently cited is this, in the Odem loco, etc. I confess that it has appeared to me that this sentence is more to be admired for the neatness of its Latinity than for its merits as a legal definition. It seems to me to be open to the objection of being, at least in the first branch of the sentence, expressed in figurative language. Moreover, it depends upon the manner in which it is translated whether it accords with the decisions of our courts, and I know of no sentence more difficult to translate. Almost every important word presents some difficulty. Lair, which even to a Roman was a figurative expression, may be properly translated household, meaning by the term the united body, consisting of a man and his wife and children and domestics dwelling together in one abode. Lair does not signify the place of abode. The words are in eodem loco ubiquis lair constituit, i.e., a man has his domicile in that place where he has established his lair. The word must mean not the place of residence, but the body which resides there, or perhaps more correctly, the act of co-residence as members of the same family. It is not easy to suggest a translation of the words rerum maci fortunum summam which shall be faithful to the original, and at the same time convey to the mind a precise and definite idea. Res probably here signifies business. Fortune no doubt means possessions or property, but what does summa mean? The proper meaning is the sum or aggregate, but it is, perhaps, here used to signify the chief or principal part or bulk. Mr. Justice Story evidently felt the difficulty of rendering this branch of the sentence into English, and in order to give something intelligible he has sacrificed accuracy of translation. He renders it thus: there is no doubt that every person has his domicile in that place which he makes his family residence and principal place of his business. This is obviously rather a paraphrase than a translation. Again, the term peregrinari in the last branch of the sentence requires a particular translation to make the definition agree with the decisions of our courts. The word properly means to be in a foreign country, but if it is so translated, it militates with the proposition now well established, that a man may establish a domicile in a foreign country, and in which he still continues to be a foreigner. The word peregrinari must therefore be translated to be a wanderer, viz., from home, and so Mr. Justice Story translates it. Therefore, if this celebrated passage from the Roman law is to be used as a definition by which our courts of justice are to be guided, I think it must be translated in some such form as this: there is no doubt that every person has his domicile in that place where he has established his household in the chief part or bulk of his business and property, from which he is not intending to depart if nothing calls him away, from which when he goes away he seems to be wandering from home, and when he has returned he has ceased wandering. Thus translated, the sentence may not be objected to on the score of inaccuracy, though it is still open to the observation that a man may have his family residence, his lair in one country and the chief part or bulk of his business, rerum maci fortunum summam in another. Section 61. Id. Definitions of the Digest. Another passage from the Roman law is frequently quoted and treated as a definition. It is by Ulpian, is found in the Digest, and is as follows: Si quis negotia sua non in colonia, stin municipio sempragit, in illo vendit, imit, contrahit, eo in fora, Barlenio, spectaculae suiticia, ibi festos dies celebrat, omnibus denic municipi comedies, nullis colonarum, frucia, ibi magis habere domicilium, quam ubico lindi causa divusata. Most of the criticisms made upon the passage above quoted from the Code apply also to this passage. It is apparently a statement of the most usual criteria of domicile to be found in the life of a Roman, and is therefore more properly a formula of evidence than a definition. Alpha News Varus, in a passage also to be found in the Digest, in answer to the question quidis domum ducia says, Sta ea reconstitutum esse, eam domum unicuic nostrum debir existimari, ubiquisque sed et tabulas habret, sarum crurum constitutionum fecisit. But this definition, far from solving the difficulty, only increases it. For what are we to understand by sed et tabule, and what by rerum constitutio? Section 62. Other definitions: Donellus, John Voet, Hirtius, Pothia, Vattel. Donellus, after criticizing and pointing out the uncertainty of the expressions used in the passage above quoted from the Code, suggests as more concise and certain a definition of his own, as follows: Locus, in quoquis habitat eo animo, ut ibi perpetuo consistat, nisi quid avesset. John Voet says, "Alid in superpropria dictum domicilium est, quod quis sibi constituit animo in non decidendi, si non alid avesset." This definition Kindersley, V.C., in Lord V. Colvin, considers as little open to objection as any. Hirtius defines domicile, ubiquis frequentius ac ducius comeraris solert, rerum casi fortunum sarum majorem partum constituit. Pothier, in his introduction to Book 50, title, of the Pandects, generalizes the Roman definitions thus: domicilium facit potissimum seds fortunum sarum, quis in alico loca habet. Vattel describes domicile as an habitation fixed in any place, with an intention of always staying there. This definition has been frequently quoted and criticized. Story, following Parker, Justice, in Putnam v. Johnson, says, but this is not an accurate statement. It would be more correct to say that that place is properly the domicile of a person in which his habitation is without any present intention of removing therefrom. Cujas combines in one the several Roman definitions thus: domicilium cujuscibus tubularem fuvit, ubi sed et tabulas rationum sarum habet, ubi remet fortunum sarum summam constituit, ubi sidu versata, negociata, ubi majorem suorum bonorum partum habet, ubi festos dies agitat, uticia fora eodem, balneo eodem, spectacules. Section 63. Definitions of French jurists. The French writers have made frequent attempts at the definition of domicile. In addition to the several already given, the following may be noted. Denisot says, domicile is the place where a person enjoys his rights, and establishes his abode and the seat of his fortune. Pothier says, it is the place where a person has established the principal seat of his abode and of his business. The Encyclopédie Moderne defines it thus: it is, properly speaking, the place where one has fixed the center of his business. The French Code declares, the domicile of every Frenchman, as to the exercise of his civil rights, is at the place where he has his principal establishment. Demolombe, in commenting upon this definition, after quoting also the definition contained in the Roman Code, says, such is also the thought of Article 102, when it declares that the domicile of every Frenchman is at the place of his principal establishment, that is to say, at the place which he has made the center of his affections, of his affairs and habits, the seat, in fine, of his social existence, rerum ac fortunarum sarum summam, at the place where he is established in a manner permanent and durable, with the intention of being there held, of being there attached, of their returning sooner or later whenever he is absent. It must be understood, besides, that this word, establishment, ought here to receive a very broad interpretation relatively to all the situations so diverse and so varied of which society is composed. The aged servant has his principal establishment in his little solitary chamber, just as the most opulent père de famille in his hotel or the merchant in his house of commerce. In what place, above all, has he established his fixed abode? Where is found, if I may so express myself, his chief place, having regard to his personal situation. Such is the question of domicile, a question necessarily altogether relative. It is necessary, moreover, not to confound domicile with residence. The one is de droit, the other is de fait. Residence may be assuredly one of the indices of the principal establishment which constitutes domicile, and we say even that the actual habitation is one of the conditions demanded when the question is concerning the changing of it. But it is not the less certain that domicile does not depend upon residence, for it is an effect of the law, a juridical creation, a thing intellectual and abstract. It consists, as we have said, in the moral relation of the person with a certain place where the law has placed the juridical seat of such person, independently of the fact of residence. It is indeed that, above all, which constitutes the utility of this institution, for it has precisely for its object, to determine in a manner regular, fixed, and constant, the domicile of the person apart from his removals, his travels, his residence more or less accidental and transient in other places. Domicile consists, says Proudhon, in the moral relation of a man with the place of his residence, where he has fixed the administrative seat of his fortune, the establishment of his affairs. We say in the moral relation, because domicile does not consist in physical existence or in actual residence in a place, but in the attachment contracted by the person for the place chosen for the center of his negotiations. Dementi says, it is an effect of law which consists in the relation established by law between a person and the place where he exercises his rights. Ortolan says, domicile is nothing else than the legal seat, the juridical seat of every person, the seat where he is considered to be in the eyes of the law, for certain applications of the law, whether he be corporeally found there, or whether he be not found there. Marcade remarks, domicile is then the legal seat, the juridical seat, of the person. We say the juridical seat, for domicile is not, properly speaking, the house, the material construction. It is a thing altogether ideal, a thing moral and abstract, resulting solely from the creation of the law. And again, domicile is the seat, purely moral and juridical, which the law attributes to each person for the exercise of the rights existing for or against such person. Section 64. Definitions of Savini and Calvo. Savini thus defines domicile: that place is to be regarded as a man's domicile which he has freely chosen for his permanent abode, and thus for the center at once of his legal relations and his business. The term permanent abode, however, excludes neither a temporary absence nor a future change, the reservation of which faculty is plainly implied. It is only meant that the intention of mere transitory residence must not at present exist. One of the latest definitions is that of Calvo, who, though a South American diplomat, may be classed among the continental jurists. He says, in its juridical acceptation, domicile is the legal seat where a person is presumed to be in contemplation of the law and for the application of the law. According to this definition, domicile would be an abstraction purely intellectual, created solely by the law, an effect of the law consisting in the relation established between the person and the place where he exercises his rights. In a usual and more practical acceptation, is meant by domicile the place itself, where a person has established the seat of his affairs and the center of his interests. Section 65. American definitions. Story, President Trush, Parker, J., in Putnam v. Johnson. Story's definition, which has been so often and so deservedly quoted, is as follows. By the term domicile, in its ordinary acceptation, is meant the place where a person lives or is his home. In this sense the place where a person is his actual residence, inhabitancy, or commorancy, is sometimes called his domicile. In a strict and legal sense that is properly the domicile of a person where he is his true, fixed, permanent home and principal establishment, and to which, whenever he is absent, he has the intention of returning, animus revertendi. President Trush, in the leading American case of Guy v. O'Daniel, defines domicile to be a residence at a particular place, accompanied with positive or presumptive proof of continuing it an unlimited time. This definition has been much quoted, and with general approbation. It is highly commended by Calvo, is repeated by Phillimore with a slight modification, and through the influence of his authority has produced some effect in the English cases. The definition of Parker, Justice, in Putnam v. Johnson, in the slightly inverted form in which it has been given by Story, has also been received by many jurists in this country as accurate. In that case the learned judge, commenting upon the definition of Vattel, says, the definition of domicile, as cited from Vattel by the counsel for the defendants, is too strict, if taken literally, to govern in a question of this sort, and if adopted here, might deprive a large portion of the citizens of their right of suffrage. He describes a person's domicile as the habitation fixed in any place, with an intention of always staying there. In this new and enterprising country it is doubtful whether one half of the young men, at the time of their emancipation, fix themselves in any town with an intention of always staying there. They settle in a place by way of experiment, to see whether it will suit their views of business and advancement in life, and with an intention of removing to some more advantageous position if they should be disappointed. Nevertheless, they have their home in their chosen abode while they remain. Probably the meaning of Vattel is that the habitation fixed in any place, without any present intention of removing therefrom, is the domicile. At least this definition is better suited to the circumstances of this country. It is to be remarked, however, that Putnam v. Johnson was a case of municipal domicile, and it will be seen further on in this work that the definition given by Parker, Justice, is not applicable to cases of national or quasi-national domicile. It is believed that this distinction has been overlooked by many of the judges who have sought to apply this definition with sometimes unfortunate results. The Louisiana Code, following the French Code, declares, "The domicile of each citizen is in the parish wherein his principal establishment is selected." An opinion of the Louisiana Supreme Court, in applying this definition, defines further thus: "A man's domicile is his home, where he establishes his household and surrounds himself with the apparatus and comforts of life." Wharton defines domicile as a residence acquired as a final abode. Section 66. Definitions of English judges, Kindersley, V.C., in Lord v. Colvin, Lord Wensleydale in Wicker v. Hume. The English judges have, with several exceptions, studiously avoided defining domicile. Kindersley, V.C., who has decided more cases on the subject of domicile than any other single English judge, after carefully considering the definitions in the light of the decided cases, suggests this: that place is properly the domicile of a person in which he has voluntarily fixed the habitation of himself and his family, not for a mere special and temporary purpose, but with a present intention of making it his permanent home, unless and until something, which is unexpected or the happening of which is uncertain, shall occur to induce him to adopt some other permanent home. This definition, however, is unfavorably criticized by Lord Chelmsford in the same case on appeal. Lord Wensleydale, in Wicker v. Hume, adopts this as a very good definition: habitation in a place with the intention of remaining there forever, unless some circumstance should occur to alter his intention. Section 67. English text writers, Phillimore, Foote, Westlake, Dicey. Phillimore, in his work on our subject, referring to some of the dicta of American judges, who he says have been most successful in their attempts at definition, frames the following as a tolerably accurate definition: a residence at a particular place, accompanied with positive or presumptive proof of an intention of remaining there for an unlimited time. It will be seen that this is based mainly upon the language of President Rush, in Guyer v. O'Daniel. It has been much quoted, and probably has had considerable effect in fixing the description of the animus manendi requisite for a change of domicile. The introduction into it, however, of the words positive or presumptive proof of, which also are in President Rush's definition, is criticized by Dicey as being at best superfluous, upon the ground that the maxim de non apparentibus et non existentibus idem est ratio is in law of universal application, and a fact which cannot be proved to exist has for legal purposes no existence, and further, that they tend to confuse together the inquiry, what is the nature of the fact constituting domicile, or, in other words, its definition, with a different question, what is the evidence by which the existence of this act, when its nature is known, can be proved. Foote defines domicile as the relation of an individual to a particular state, which arises from his residence within its limits as a member of its community. Westlake says, domicile then is the legal conception of residence, and the two words differ no otherwise than, as in all sciences, common words, on becoming technical, are limited in meaning for the sake of precision. The objection to this statement as a definition, if indeed it was intended as such, and probably it was not, is that residence, particularly in American law, is used in various senses, sometimes technical, sometimes untechnical, and even when used technically its meaning is not, as we shall see further on in this chapter, definitely fixed, but depends much upon the subject to which it is applied. Dicey, in his valuable work on this subject, defines domicile to be the place or country which is considered by law to be a person's permanent home. And this, with perhaps one change, is as nearly accurate a definition as has been given. Attention will be called further on to the fact that domicile is not strictly, in a legal sense, the place where a person has his home, but expresses the connection between such person and place. Section 68. Definitions usually not broad enough to include all phases of domicile. Most of the so-called definitions of domicile are not definitions of the term in its general scope and meaning, but of domicile of choice, or that which is acquired by the act and intention of an independent person, and, therefore, do not cover either domicile of origin or that imputed by law to dependent persons. Moreover, even as definitions of domicile of choice or acquired domicile are usually defective, in that they relate only to the time of the acquisition of such domicile, and do not provide for its retention by actual residence, where there has been a change of intention, or by intention, where there has been a change of actual residence. Again, many of them are not properly definitions at all, but mere formulae of evidence framed apparently for the purpose of succinctly stating the most usual criteria by which domicile of choice is determined. Section 69. Is domicile place or legal relation? There has been considerable metaphysical discussion, of perhaps no very profitable nature, in France with regard to one point in the definition of domicile. Some jurists define it as the place where, etc., others as at the place where, etc., and others again as a relation between a person and the place where, etc. The first form of expression, as appears from the definitions above quoted, was in common use in France prior to the adoption of the Code Civil, and not in France only, but elsewhere, and it has continued to be used in many of the American and English definitions down to this day. This evidently was not the idea of the Roman law, as is shown by the expressions in eodem loco singulos habeat domicilium non ambiguitur ubi, etc. Ibimigis habeat domicilium. Rilgatus in eo loco. Domicilium habet. Domicilium autem habea patistet relegatus eo loco. Pluribus lucis domicilium habea, etc. The jurists whose writings compose the body of that law were careful to preserve substantially the expression to have domicile in the place, nowhere declaring that domicile is the place. In the first draft of the Code Napoleon, it was said, le domicile. Est le lieu, but this phrase was amended so as to read le domicile. Est le lieu, and since the adoption of that code French jurists in general have sought to conform their definitions to its language. But in endeavoring so to do, some, among whom are Proudhon, de Molambe, and de Monti, have described domicile as a relation between a person and a place, and this has been vigorously combated by others, among whom are Ortolan Superscripto and Marcade. To serve a writ, to make a demand at the domicile, or to summon before the tribunal of the domicile, say the last-named jurists, would be to serve a writ, to make a demand at the legal relation, or to summon before the tribunal of the legal relation, a strange cacophony, says Ortolan. But such criticisms, as has been justly remarked, might be expected rather from a grammarian than from a jurist. Both of these writers describe domicile as the legal or juridical seat of a person. But what is the legal or juridical seat of a person, if it does not express a relation of the person with a place? Marcade, however, while admitting the idea of legal relation, holds that domicile is the seat which the law creates in consequence of that relation. The truth is that the question may be looked at from several sides, and it probably might be quite as plausibly argued that domicile is the relation, and the juridical seat is the consequence of domicile. It therefore seems to the writer entirely accurate to describe domicile as a relation between person and place. This view has been taken in Bell v. Kennedy by Lord Westbury, who says, domicile is an idea of the law. It is the relation which the law creates between an individual and a particular locality or country. Section 70. Domicile and home. Similarity. It may be correctly said, remarks Grier, J., in White v. Brown, that no one word is more nearly synonymous with the word domicile than our word home. Domicile answers very much to the common meaning of our word home, and where a person possessed two residences. The phrase, he made the latter his home, would point out that to be his domicile. And the two words have been pronounced to be substantially equivalent in many cases both in this country and in England. Thus, for example, dwelleth and hath his home, as used in the Constitution of Massachusetts, are construed by the Supreme Court of that state to have reference to domicile for the purpose of voting, and are used as synonymous with that term with reference to various other purposes. Such undoubtedly was the idea also of the Roman law at a time when the notion of domicile was much less technical than it now is. Section 71. Id. Differences. There are several objections, however, to affirming the entire and universal equivalency of domicile and home. First, because, while the former is a word of at least approximately precise meaning, the latter is used in various significations. For example, a. With reference to a temporary abiding place, as when one speaks of going home to his lodgings, and this certainly is not domicile. 6. With reference to a permanent or usual abiding place, as when one in emigrating to a new country says, "Here I fix my home," or when an Englishman during a temporary absence on the continent says, "My home is in England," or c. In a figurative sense with reference to a former place of abode for which great attachment is felt, although the person may not retain the slightest expectation or intention of returning to it, as where a colonist speaks of the mother country as home. In addition to these, various other shades of meaning have been attached to the word, and this unsettled and varying signification has led many jurists, when they wish to employ the word home in their descriptions of domicile, to qualify it with some adjective word or phrase expressive of permanency. Primarily and properly, perhaps, home includes the idea of permanency, but contrary usage seems to render the express qualification useful if not necessary. Second, when used in the sense last described, i.e., in connection with the qualifying idea of permanency, the home of the person usually corresponds with his domicile, but not always. The conception of domicile, being a creation of the law, contains within it certain legal fictions established for the purpose of giving greater precision and certainty in the application of various rules of law. But these fictions are not recognized as belonging to the ordinary conception of home, and consequently a person's domicile and home may be in different places. Take, for example, the case of a married woman living apart from her husband by mutual agreement without sentence of a court. Clearly her home in the ordinary sense of the word is not that of her husband, and yet the law by a fiction imputes to her a home with him, or perhaps, to speak more accurately, the law closes its eyes to the real facts, and will not suffer it to be alleged that man and wife live apart. Again, when a person sui juris, and capable of acting for himself, quits the place where his settled abode has been fixed, intending never to return, until he fixes himself in a sufficient manner elsewhere, he is clearly homeless in fact, yet he is not without domicile. For the law, to attain certain wise results, imputes to every person a domicile somewhere, and for this purpose holds that a domicile when once established cannot be lost by mere abandonment, but continues until another is acquired. It thus results that a person may be in the position of having a domicile but no home in the ordinary sense. Section 72. Id. Home, the fundamental idea of domicile. But in spite of this lack of entire correspondence between the two conceptions, home is the fundamental idea of domicile, and this cannot be kept too faithfully in view. The law takes the conception of home, and molding it by means of certain fictions and technical rules to suit its own requirements, calls it domicile, or perhaps this may be best expressed by slightly altering Westlake's statement and saying, domicile is the legal conception of home. To combine, then, what has been said in this and the last preceding sections, domicile expresses the legal relation existing between a person and the place where he has, in contemplation of law, his permanent home. Section 73. Domicile and residence. Residence is another word which is frequently used in connection with the subject of domicile. But great caution must be observed in its employment, as it is a word of very indefinite meaning, and to which different significations and many shades of meaning have been attached. It is frequently used in the sense of mere bodily presence in a place, without reference to time or continuance. It is employed sometimes to denote mere temporary presence in a place, and sometimes to denote the most settled and permanent abode there, with every conceivable shade of meaning between these two extremes. It is sometimes used to signify the act of residing at a place, sometimes the place where a person resides, and at other times the relation between person and place. It commonly imports something less fixed and stable than, and to that extent different from, domicile, and a distinction is taken between the actual and legal residence, the latter being generally deemed equivalent to domicile. A person may have his residence in one place and his domicile in another. Again, while he can have but one domicile, he may have two or more residences, and, on the other hand, he may be without an actual residence, although he cannot be without a domicile. Section 74. Id. Attempts to define residence. Various attempts have been made to define residence. Dicey defines it as habitual physical presence in a place or country. qualifying the word habitual by saying that by it is meant, not presence in a place or country for a length of time, but presence there for the greater part of the time, be it long or short, which the person using the term residence contemplates. In Frost et al. V. Brisbane, Nelson, C. J. says, there must be a settled, fixed abode, an intent to remain permanently at least for a time, for business or other purposes, to constitute a residence within the legal meaning of that term, and this he intimates is actual residence as contradistinguished from domicile. In Morgan v. Nunes, it is said, residence implies an established abode, fixed permanently for a time for business or other purposes, although there may be an intent in the future, at some time or other, to return to the original domicile. In Long v. Ryan, Staples, J. says, according to the most approved writers and lexicographers, residence is defined to be the place of abode, a dwelling or habitation, the act of abiding or dwelling in a place for some continuance of time. To reside in a place is to abide, to sojourn, to dwell there permanently or for a length of time. It is to have a permanent abode for the time being, as contradistinguished from a mere temporary locality of existence. The act of abiding or dwelling in a place for some continuance of time. In Tazewell v. Darnport, it is said, a resident of a place is one who dwells in that place for some continuance of time for business or other purpose. Section 75. Id. Residence in American legislation generally, although not always, means domicile. The word domicile, although so often used and commented upon by our courts, is rarely to be met with in our constitutions or legislative enactments. Residence is the favorite term employed by the American legislator to express the connection between person and place, its exact signification being left to construction, to be determined from the context, and the apparent object sought to be attained by the enactment. It is to be regretted that these lights are often very feeble, and that not a little confusion has been introduced into our jurisprudence by the different views held by different courts with regard to the exact force of this and similar words when applied to substantially the same subject matter. Residence when used in statutes is generally construed to mean domicile. In fact, the great bulk of the cases of domicile reported in the American books are cases of statutory residence. This is especially true with regard to the subjects of voting, eligibility to office, taxation, jurisdiction in divorce, probate and administration, etc. With respect to these subjects, there is substantial unanimity in this country in holding statutory residence to mean domicile. In cases of pauper settlement, limitations, etc., there is much conflict of opinion, and in those of attachment the weight of authority is the other way. Section 76. Domicile and inhabitancy. Habitancy or inhabitancy is another word which is also often construed to mean domicile, but this depends much upon the connection in which, and the purpose for which, the word is used. In some cases it has been held to mean less than domicile, and in others more, implying, in addition to what is included in that term, citizenship and municipal relations. But in general, statutory inhabitancy is construed to be substantially equivalent to domicile, at least, in the language of Sure, C. J. in Otis v. Boston. Most of the rules of the law of domicile apply to the question, where one is an inhabitant. Section 77. Domicile, national, quasi-national, and municipal. Whatever may be the true definition of domicile, it expresses, at all events, a connection between person and place. But the term place is an indefinite one, and may be used to denote a larger or a smaller division of territory. There was no difficulty whatever upon this point under the Roman law, since, generally speaking, but one unit of place was recognized, the urban community, and to this single unit the relation domicilium always referred. But among modern civilized nations units of place have been greatly multiplied, and differ in number and kind in different countries. Although not absolutely the largest, yet the largest known to the law is the sovereign state in its territorial aspect, while the smallest are the various municipal divisions, such as town, township, ward, parish, etc. Between these two extremes, and approaching more or less nearly to one or the other, are numerous territorial divisions, some rising into quasi-autonomy, and others, instituted for purely municipal purposes, nearly approaching the smallest. It is evident that any of these various territorial divisions may be the seat of man's domicile or home, so that while his abode remains at one spot, the scope of the relation signified by the term domicile, viewed with reference to different purposes, may vary from the smallest to the largest unit of place. The relation has been appropriately termed national domicile when its seat is a country, and municipal or domestic domicile when its seat is one of the smaller municipal divisions. We will use the term quasi-national when we desire specially to speak of that domicile which has for its seat a quasi-autonomous state, such as the states of this Union, or the various countries and colonies composing the realm of Great Britain. This distinction is not known in England, but is palpably recognized in many of the American cases, even where it is not expressed in terms. It would, however, be a mistake to suppose that these several phases of domicile are distinct things, for they do not differ otherwise than as a part differs from its whole. Thus a man is said to have municipal domicile when the town in which he has his home is considered, and national domicile when the country in which the town is situated is looked at. But the one includes the other. A person who has a municipal domicile in a Massachusetts town is also connected with the territorial division known as the state of Massachusetts by the tie of quasi-national domicile. And the converse is generally, although not universally, true, namely, that a person who is connected with a great division of territory by national or quasi-national domicile also has a municipal domicile at some place within that state or country.